Hello everyone, we are very happy to have you all at this event today. My name is Ike Stevenson. I co-founded Just for Kids Law with Shawneen Lamb about 17.5 years ago, and I am the legal director and currently practicing as a criminal solicitor. In 2020, Just for Kids Law received funding from the Barrow Cadbury Trust to improve criminal representation for Black, Brown and racialised children. And we are extremely grateful that this funding has enabled us to create what we think are incredibly powerful tools for criminal practitioners to fight racial injustice in the legal system. Just for Kids Law has always worked closely with the young people we represent. And so one of our favourite parts in the creation of these guides and training materials was to explore in depth with young people the problems that they themselves see in the criminal justice system that relate to race and unfairness. We are really grateful to the young people who shared their experiences and ideas, and their suggestions have driven forward the creation of these tools, which we hope practitioners will use to tackle the racism that is systemic in the criminal justice system. The voice of the young people, their sense of fear and exclusion came across clearly in the animation, which we hope will gather a much wider audience outside of our legal community. Having heard what the young people said and gathered their helpful suggestions, we used this as a starting point to create tools that can be a part of the solution. With our esteemed advisory group, many of whom you will recognise as leading voices in the criminal justice system and beyond. I was privileged to chair this advisory group, who all actively engaged with their own experiences and the problems we had encountered for the Black, Brown and racialised young people in the criminal justice system. Our goal was to work towards solutions and changes. We know this won't happen overnight, but every step in the right direction is a step towards equality. We soon realised there were many more identifiable problems that practitioners could address when representing Black, Brown and racialised children in the criminal justice system. So that's why our original idea of one guide turned into 3, because there was just so much to say and so much to learn. This is a piece of work that stands on the shoulders of giants, building on all of the horrors identified by the Black Lives Matter movement. The young people we worked with were clear that they believe the race problems we have in the UK are more invisible and insidious than those in the States, because we don't have a public historic narrative of slavery. And they were very keen that we focused on the issues here in the UK. In the UK, in 2017, the Lammy Review highlighted the problems faced here. And since then, other incredibly helpful tools have been created by civil society, such as Justice and the Howard League for Penal Reform. However, the 2021 statistics from the Youth Justice Board show that the criminal justice system and people who work within it continue to discriminate, sadly. We are grateful to the Youth Justice Board. The fact that the discriminatory treatment of Black, Brown and racialised children has been scrutinised by the YJB and publicly published has meant that we are allowed to critique the system and acknowledge these things out loud, because the statistics show they can no longer be ignored. We believe that every lawyer representing a Black, Brown or racialised child has a duty to see the circumstances through their client's eyes and to relay this to the people with power. We've brought together some of the leading voices in change to talk to you over the course of the next 4 weeks. And we hope that the skills gained will enable practitioners to improve the way they advocate for their clients and to ensure that race as a discriminatory factor is not ignored and is outed. We really hope that these trainings can be interactive, and please do ask our experts questions. If you put them in the Q&A rather than the chat, then they will head my way. And we hope to develop a rich conversation in this space about these issues. So firstly, the first event, or the first piece we're going to show you, is the film that has been created called Judge. And we love this animation that has been created by Ronaldo and Ed, who you will hear more about later. It's based on the experiences and voices of the young people and the experiences they shared with us, and what it feels like to be a young person or a child in the criminal justice system. So we'd like to thank everyone for all the hard work that has gone into it by the filmmakers and the Youth Justice Legal Centre.
Why?
Ike, sorry, you're on mute there.
So we are really pleased to have Ronaldo Pele here, who is a BAFTA-nominated director, animator and illustrator working in 2D digital traditional animation, storyboarding, character design and illustration. Ronaldo's work is characterized by a combination of slick digital and tactile analog approaches. Thematically, his projects center around social and personal issues with an emphasis on subtle, emotive, human character performance. Produced at the NFTS, his atmospheric paint on glass film, The Fire Next Time, about the 2011 riots, blends hand-painted character animation with stop motion sets. It premiered at Annecy Festival and has gone on to feature at Sundance. Ronaldo is the director and animator of Judged, the short film made by YJLC with a group of young people about what it feels like to be a child going to court. And so I have the pleasure of introducing Ronaldo and also being able to ask him a few questions. So it's really great to have you here.
Hi.
Hi, Ronaldo. So can I ask you first how what your initial reaction was when Katia contacted you about the project and how you felt about that?
I was really excited, actually. I had previously worked with Just for Kids Law a few years back on another short film with a director called Frank Burgess. It was a short film about mothers that were at risk of losing their children to the care system. And I had a really good time doing that. And I always feel like it's really important to make work that you feel connected to and that you feel has like an impact, basically. So it was really exciting to kind of get the shout about this new project, and it's you know, it's something that's close to my heart because I've got family members and that have been through the criminal justice system when they were young. So then I've seen firsthand how that impacts people's lives.
And so did that throw up any memories for you when you were creating the film and sort of reflecting on those experiences?
Yeah, I think like one of my older brothers was in and out of trouble when he was younger, and I always just remember going to the courts and how alien the environment is, how kind of isolating that could be, and that's just as a family member. So then I can't imagine what that's like to go there as the person in the stand and you know, having your life in someone else's hands. So definitely it kind of threw back all those memories about how strange it is and how intimidating that can be.
Yeah, and I think we felt that that's what you captured so amazingly well in the images, and we have played these to some magistrates recently, and they were completely blown away by it. And so I think, I think the visual images are really, really powerful, and you have managed to convey the feelings of children. So, we're extremely grateful for that. So you make many animations about pressing social issues. So would you like to tell us a bit more about some of your other films?
Yeah, I mean, so I always try and make things that are like centered around either the community or around just people's personal struggles. So my graduation film from the NFTS was going around last year. That's the film about the 2011 London riots, and again it's kind of looking at like how the environment is impacting the people, and then how that's affecting their decisions and stuff. And so like again, that has a lot of tie-in with the film that we've just made for you guys, obviously, because it was really interesting hearing the feedback from the young people and having them talk a bit about what they would like out of legal representation, what they feel like can kind of get lost. And some of the things that kind of caught me off guard a bit was the kind of not wanting to be kind of I suppose like mollycoddled through the experience, and a bit wanting to be told as it is, expecting to be respected as like an equal, and be kind of told the truth as it is, and not necessarily kind of lied to protect their feelings and stuff. So I think that what's interesting when you're making work like this is you learn more about other people and other people's experiences, and you get a chance to kind of share a bit of your own personal background, and so I always try and make things that kind of I have that kind of connection to, I have some kind of personal connection to, or that I feel strongly about, because I just feel like you communicate much better if you're confident about what you're speaking about.
Yeah, and I think that comes across, that comes across so well. So thank you very much.
Thank you. I'm really good.
So I'm going to have to, we've got quite a tight schedule, otherwise I would sit and talk to you all day, but please feel free to listen in, because we played the video to one of our clients and interviewed him, and so he was very much historically a client, and so we spoke to him about how he felt, and I think that it was definitely a very visual representation of his feelings. So thank you very much.
Great.
So as Ronaldo mentioned, this project, as with all of Just for Kids Law's work, is led by the voice of our clients, those who this criminal justice system impacts the most. And so at this point, I think we'd like to hear from that young man, or older man, I should say. I think there may be a slight delay.
When I was about 14, very similar situation. I just felt like I was in a world which I completely didn't understand. I was being led by a whole bunch of people that was nothing like me, to be honest. Because I was in Crown Court for the first time, it's just a whole bunch of people wearing wigs, not understanding their vernacular, like the way you talk. I was generally a bit lost, and I felt like I was being led in the dark by people, really. I do think it's a very traumatic process, only because even the situation, as a young person, you don't know when to stand. You stand up at the wrong parts, you sit down. That's actually something I did. I stood up and sit down in the wrong parts, and you're almost being corrected as no, sit down, stand up. Or like the judge is telling you to sit down and stand up. And the whole situation, but when you're introduced to anything new in life, for me anyway, I don't just run into new things. I like to understand how things work, so on and so forth. So, but you're kind of thrusted into this situation, and it's a very uncomfortable situation as it is. So when I went into court, I was in a room which I didn't understand anything else happening, but it's less my solicitor talk to me, which they only talk to you afterwards. So you walk out and you say, oh, what happened? Right? So I'm sitting in the room, feeling like my life is online, but having no clue of what's happening. And it's almost, to me, I feel like it's one of the most, like it's some of the most, it makes you feel like a victim almost. You don't feel like you're there to be judged whether you did a crime or not. It makes it feel like we're discussing what to do with you. And because you can't speak for yourself, or because you're young, you're a little boy, it doesn't feel like they say justice, but it doesn't feel like justice is happening, because there's no way to articulate yourself, or there's no way for you to understand what they're articulating to each other. So it doesn't feel that justice is happening, because you can't even understand what's happening. So how are they dictating a situation that you got yourself into, or you didn't get yourself into, without even the person in the room understanding what's happening? How are they telling the story of what's happened if you can't understand what's happening in the room, and you was the person in the situation? Because it's even when the judges ask questions, you can tell it's biased towards the police officer that's presenting himself there. So I just don't think, even if I didn't have a solicitor, even if I had the best solicitor in the world, I would have got away with anything there. So the judge in the magistrate's court seems so much more emotionally strong, and so much more gender, like their opinion was made up way before I was in the room. So as there's a bit more of a professionalism when it comes to Crown Court trying to judge whether their opinion is made up or not, and it might be, but you can tell it is in the magistrate's court, and that's what one of the problems is in magistrate's court. I'm from an environment where you're not really around white people. Well, at that time in my life, I'm around family, friends, which all like me. So that in itself is uncomforting. And if I'm being honest, up until this day, I don't really know why they wear the wigs and the gowns, but like that's an even more intimidating part of the process, because they're all dressed slightly different. And you're sitting there thinking, as a young person, that all this judge is seeing as a young black male, I'm just another guy. Even if you didn't do it, or didn't do it, you're thinking it doesn't matter. His opinion is already made up of me. So me wanting to talk and explain myself was almost because I didn't want him to view me as the next person walking through the door, because he probably bangs that hammer 100 times a day, and he just, as everyone does without knowing it, he would just generalize people. I was scared. You're left in the cell for ages.
How long's ages?
Well, it's difficult to say ages, right? Because you're there all day, essentially, and you're there for the morning. But it's a bit different. The hours go a lot slower and the minutes go a lot slower when you're just locked in a cell. You don't know anyone. The govs don't talk to you. They don't communicate with you. It's like you're like being a ship's dog, essentially. There's no clock there, so it feels like the time's a lot longer. And your break of that time being long is your solicitor coming to talk to you. I didn't understand what's going on in court because they're not talking even traditional in English. They're saying things in a very complex way, especially for a 14-year-old. Even as you get older, a lot of the stuff you don't understand what they're saying. But that's another thing. It's almost my best way of describing court and lingo, right, is when you're really young and you used to go, for example, to a reception or a church, right? When you're really young, you're not really taking it in properly because your understanding of things may be very different. And that's the way I'll describe court, is that because I was so young, I wasn't really taking it all in or understanding things. I used to ask my solicitor a lot of the time, oh, what happened? Or what was his opinion on that? Because you can't fathom or grasp even the air in the room properly because it's like they're almost talking a different language to you. So, yeah, that is definitely an intimidating thing. And I think one of the most intimidating things is not knowing to speak or when you're being spoken to because you're afraid that you're being rude because the judge may speak to you, but you didn't know that they had actually turned to speak to you because they're just talking gibberish to you. So I think that's what one of my biggest pains was in that whole situation, is that I just couldn't grasp what was going on enough. I feel sorry for them, especially because even like I've had loads of friends that have been through this similar experience when I was a kid, and you could tell that they was distraught by the way situations happened or the way they felt unjust by a situation. Like, for example, when I was a kid, the joint enterprise thing was a massive thing. The way they articulate it was always, to me, it was always they wasn't heard. Like, they, not saying that they wanted to talk themselves, but it's the way they articulated it was, it never happened like the way the court was saying it. Or so I'm looking for retrial because the judge wasn't listening, or my solicitor was rubbish, or there was always it was always courtroom situations rather than, oh, I didn't do this or I didn't do that. I think it's a barrister that comes to talk to you, and they only can talk to you for 5 minutes, and you almost feel like whether you've done it or not, there's no option for you in this situation. You're being told, and luckily the first time for me, I had quite a reassurance solicitor, but I still at the same time I didn't know the person. There wasn't no confirmation of what to say and what not to say, because even my solicitor, which would have been a familiar place from the police station, wasn't there. So I just meet my solicitor for the first time, or my barrister for the first time in that court. And they're telling me, but also it's a bit of a weird situation because as young humans, we learn a lot from TV, right? And what we sometimes learn from TV in those days, like when you're watching a bill or when you're watching, is that a duty solicitor or those solicitors are not correct for you. So even what they are telling you, it feels unfamiliar to trust. They're saying they're relaying stuff from your mum, but because your mum would be a lot more harsh with you, they're not relaying it in the way your mum would be for something.
So you don't know if they're making it up.
Yeah, so you don't know if they're articulating it in the correct way, or maybe they're editing stuff out, or so you're essentially in the wilderness. So the only confirmation I was aware of was a thumbs up from my mum in the gallery when I arrived. In a lot of those situations, I realised that it's like the kid's dismissed. They talk to the parents, they're off. They need to go do something else. And I think that's what one of the problems is right there. But also the non-belief in you as a person, even when they do the consultation for the 5 or 10 minutes before you go into court, it's almost like they're desensitized to the situation itself. So they're being like, oh yeah, this is gonna happen, so on and so forth. But they don't realise your heart is trembling when you're sitting next to them. When the judge asks you to speak, you're stuttering. Okay, one of the things is when you're a kid, a lot of the time given, they don't have much time with the client, but a lot of the time given is given to the parents, right? So they will talk to the parents, but there's no real reassurance to you sometimes. You can't even get out your words properly or know what you're saying correctly, and that's because the comfort of, oh, you're right, okay, well, this is going to happen, and being talked through the process is sometimes not clear enough because they're in a rush. They've just come out of another call. They don't really have the time to explain to you. And their franticness almost feeds into your anxiety. Clear advice or if you used to ask him an opinion, what do you think will happen to me? He will tell you. He's not going to go, oh, well, you might go home, you might not. He will say, I don't think you're going to go home today. I think you're going to get remanded. And just having that, even if it's the worst case scenario, just having that in your head, it can mentally prepare you for something. A lot of solicitors will kind of, well, not a duty, but they'll have the conversation with the other side before they go into court, or they'll have the confidence in court enough to know their stuff and be like, actually, you can't do that. It needs to be done in this way, and so on and so forth. I think just it's taking the actual care to understand what's actually gone on in the process, rather than just another slammed door. I think that it's soliciting magistrates is taking the actual interest in the case and actually reading through it properly and understanding what it is and also advising their client on properly whether it will go up to Crown or whether it won't.
Sorry, Ike, you're on mute. You're still on mute.
Sorry, I really thought we would have got used to that by now. But we hope you would agree that the words of the people who've experienced the criminal justice system are the most important and the best form of expertise. But now we'd like to turn to some of our professional experts. So first, I'd like to introduce Chris Henning, and we are extremely grateful to have had the support of Chris Henning alongside us in creating these guides. This area of law is her area of expertise in the States, and Chris is a professor at Georgetown University Law Centre, whereas she is Deputy Director of the Juvenile Justice Clinic. Chris is best known for her work in juvenile defence and for her critically acclaimed book, The Rage of Innocence: How America Criminalises Black Youth. In 1997, Chris joined the staff of the Public Defender Service for the District of Columbia, where she continued to represent clients and helped to organise a juvenile unit designed to meet the multidisciplinary needs of children in the juvenile justice system. Chris served as lead attorney for the juvenile unit from 1998 until she left the Public Defender Service in 2001.
Hello, everyone. I am Kristen Henning, Professor of Law and Director of the Juvenile Justice Clinic and Initiative at Georgetown Law School in Washington, D.C. Thank you for joining us in our conversation about unconscious racial bias in the youth legal system. I imagine that many, if not most of you, have had some training, some conversation, some reading about unconscious bias. But I hope today's conversation will be different because I really want us to focus on blind spot bias as a lived experience for the youth and families that we serve. I also want us to talk about strategies to interrupt bias when we see it. And I want us to talk about strategies to break our own bias habits. So to get us started, I want to show you a very short clip. And I want you to pay attention to two things. First, I want you to pay attention to the characters in this film, right? And what's happening, what they're doing. But equally important, I want you to pay attention to how your physical body feels as you're watching. And I want you to take a pen and I want you to jot it down. Pay attention to how your physical body feels. Okay, so I want all of us to take pen and paper. We need a pen and paper for this film today. I want us to take our pen and jot down one word or more that describes how this clip made you feel. One word. And what I normally get from the audience, if I were with you, I would have you yell out your words. And I would get words like angry, frustrated, scared, tense, suspenseful, nervous, infuriated, disappointed, not surprised, angry, worried. And then I would press you to now take your pen and tell me on paper, where is it that you carry these emotions? Where do you carry your anger? Where do you carry your tension? Where do you carry your anxiety in your physical body? And I would start off by saying, in my stomach is in knots every single time I watch this clip. And so I ask you, where do you carry your tension and anxiety? And I would normally get back from you shoulders, tightened jaw, clenched fist, back, neck, stomach, breathing, eyes, headache. We carry our tension and our anxiety and these emotions in our physical body. So why in the world would I ask you such a question? Why would I get us to focus on how we carry these emotions? And it is precisely because I want us to think about the impact of our unconscious biases or our impact of those biases on the lived experience of the young people that we serve. So imagine what it must be like to be the young African-American gentleman in that film, and think about what it must be like to experience a moment or an encounter like that, not just once a month, not just once a week, but sometimes once a day, and sometimes even more than once a day. And when we think about the lived impact or the impact of the lived experience on young people, we recognize that it's a cumulative experience. It's a cumulative impact on one's not only psychological state, but also on their physical health and well-being. And so we should think about the content of this film and who's in it. We've got an older white woman, we've got a young African-American male, and we have an Asian, potentially Asian-American storekeeper, right? And so the question becomes, what types of stereotypes did you see? What types of assumptions were being made about the three of them in this film? And so the first question that I ask us to think about is, what assumptions were being made about that young African-American boy? We saw that the other two in the store perceived him as a danger, as a criminal, as if he were about to steal. But more than that, right? It went one step further, and there was the assumption that he would be a danger. He would bring violence. And we know that by watching the sweat pour down the storekeeper's face, and by the fact that the storekeeper reached his hand underneath the counter as if to grab a weapon. We saw the absolute fear on the older white woman's face and in her body language when she grabbed her purse and pulled away, right? Then I ask you, what assumptions were being made about that Asian storekeeper, right? So we had the visual flash of the young African-American boy who clearly saw this Asian store clerk as an outsider, as a foreigner, as if he were a tourist walking around with camera, looking up, taking photographs, right? As if he did not belong. And then there were stereotypes about the older white woman as well, stereotypes of her being what? In a coffin. Right? And so every one of you who is watching this video, if you're older than the age of 30, I guarantee you that the young people look at you and see you also on the verge of death in the coffin. All the stereotypes were there about her playing bingo and her dentures being out. And so I ask us to just think about all the stereotypes that all three of those players had in this film and how it impacted their engagement and their encounters and their interactions with one another. That is what implicit bias is about. And then I ask you to be honest and to think about how this film not only made you feel while you were watching it, but what assumptions were you making? Was there a moment, were there encounters that you drew your own assumptions and conclusions? So I ask you to think about what assumptions did you make when the young African-American boy approached the front door of the store, right? What assumptions did you make about what would happen? And I will tell you, I'll confess to you that the very first time that I saw it, I assumed maybe that he was so frustrated with the encounter that he was having that maybe he would just walk out of the store in frustration. But instead, what did he do? Right? He grabbed merchandise from the front of the store and he went back to pay, defying all the assumptions. So that's where I want to go next. I want you, again, take your pen and just pause for a moment and ask yourself, what were all of the surprises that we saw in this film? What didn't you expect from this film? Right? So how many of you said that you didn't expect there to be tap dancing? And those of you who understood or guessed that the sound that you heard in this film would indeed be tap dancing, how many of you recognized or assumed that it would be the young African-American boy? And when I ask for a show of hands when I'm with you in person, I invariably get very few people recognize the sound as tap dancing. And those who did not recognize or expect that it would be the young African-American boy who is tap dancing. What were the other surprises? I like to ask us to think about, what did the young African-American boy buy, right? He bought an apple and water, defying all the stereotypes that we have about teenagers in general. What was surprising about the older white woman? What was the biggest surprise of all? The biggest surprise, of course, was that she stole. And what did she steal? She stole a Snickers bar. And what did she buy? She bought Cheetos. Again, defying all these stereotypes, right? So the surprise is that the young African-American boy, for many people, were surprised that he didn't steal. And yet they're surprised that the older white woman would steal. So this is a beautiful depiction. This film, Silent Beats, is a beautiful depiction of the ways in which our stereotypes and assumptions drive our daily encounters. And mind you, that film, that little clip, was only 5 minutes. Brief encounter, no words were exchanged, and yet the moment was deeply embedded with our implicit biases. So before I move on from this segment, I want to ask you to write down on your paper 1 or 2 words that describes the young African-American boy in this film. And I ask you to imagine that you were describing this boy to a youth court judge, or to a news reporter, or to a college admissions counselor. How would you describe him in 1 word? What words would you use to describe him? And I hope some of the words you have are that he was caring, He was a caregiver to his mother. He was loving. He was compassionate. He was thoughtful. He was hardworking. He was creative. He was talented. He was resilient. He was a gentleman. I also hope that you use words like he was a child, a normal teenager. He was a bike rider, a consumer. He's all the things that any other child would be. And so that's our job as we move forward in this brief time that I have with you, is to get us to think about the fact that no one demographic defines any person. This young boy is a son. He may be a brother. He is so many things. He's a student, right? But he is not defined by any one demographic. He's not defined by his race or his age. So we have been talking about our implicit biases or our unconscious biases. And as I said, I am assuming that all of you have had some experience or understanding or teaching around implicit bias. But to make sure we're all on the same page, I want to provide you with the definition that I find most useful as we think about this in very concrete ways in the youth legal system. So when I talk about implicit bias or unconscious bias, I'm talking about attitudes and stereotypes that affect three things. They affect our understanding, our decision-making, and our behavior without our even realizing it. That's exactly what we saw happening in that film. Our unconscious biases also function automatically, including ways in which we would not endorse if we were conscious or aware of those behaviors, right? It is also very helpful to understand unconscious bias as a part of the cognitive sciences, a part of the brain science. So in other words, we all rely on cognitive shortcuts to help us move throughout the day. We rely on cognitive shortcuts to filter pieces of information that we receive. We receive billions of pieces of information all day long, right? And we've got to categorize it. We've got to organize it and navigate it. And so we rely on cognitive shortcuts to do that. We also rely on cognitive shortcuts to fill in missing pieces of information. So every single time we meet a stranger, we automatically fill in missing pieces of data. And we use our cognitive shortcuts to categorize people and to categorize information according to cultural stereotypes that we have about a certain group or category of people. And it's important to recognize that our cognitive biases affect all of us, including people of the same race and ethnicity. So one last thing I want us to say before we get into the practical application is that we need to understand that our implicit biases and our cognitive shortcuts include both stereotypes and attitudes. So our stereotypes are character traits, right? So stereotypes are character traits that we tend to associate with a particular category of people. So if we wanted to use an example of elderly people, you have to ask yourselves, in your country, what are the character traits that we typically associate with elders, right? We often think of them as frail, as stuck in their ways, as poorly equipped to use computers. We might think of them and describe them as being poor drivers and having poor eyesight, things like that. But when we ask the question about attitudes, attitudes are our feelings. How do we feel about elderly people in our community? And attitudes can be positive or negative, right? So we might have negative attitudes or feelings about elderly people when we feel impatient with them. We are annoyed by them. We are also have positive feelings about them in some ways. We might be paternalistic to them. I was raised to revere my elders, right? So whenever an elderly person walks in the room, I have positive feelings about them. I revere them. I get up and I give them my seat. But the feelings can be positive or negative. And so it's important to recognize that when we talk about unconscious bias, when we talk about implicit bias, that it's not all negative. Sometimes that bias is favorable, but the key is to be aware that we have those biases and to think about how those biases make us what? Understand what's happening in front of us, make decisions, and engage them through our behaviors. Bias affects all of those things, positive or negative, and we need to be aware of them.
I would highly recommend Chris's book, The Rage of Innocence, How America Criminalizes Black Youth, because so many of the problems in America have spread here to the UK. But although there are significant differences, some of the ideas for solutions and innovation advanced by the criminal justice community can also be spread sooner by looking at their materials. Chris has also co-created the Defenders for Racial Justice Toolkit that anyone can sign up to, and we'll add the link in the chat if you would like to look at that. So it now gives me great pleasure to introduce Jo Cecil, our final speaker, to talk about the special status of children. Jo Cecil is a barrister at Garden Court Chambers. She has a mixed public law and criminal practice with particular expertise in child rights and youth justice. She has a wealth of experience in representing children and is renowned for having been instructed in many test cases relating to children in the criminal justice system, which have resulted in significant changes in the law. Joanne was instrumental in the fight against the use of the death penalty for under 18s in the US, which culminated in the case of Roper v. Simmons, which abolished the death penalty for those who were juveniles at the time they committed an offence. I work with Jo as she is as a lawyer, but also as she is a board member of Just for Kids Law and the Alliance for Youth Justice. So over to you, Jo. So there'll be a 10-minute presentation and then questions for Jo.
Well, thanks, Ike, and what a privilege it is to be in this discussion this evening. I've got to say, how do I follow that? I feel like a total novice, frankly. It's been fascinating, and it just brings into stark relief from my perspective just how far behind we are actually in the courts at the present time, which is obviously where my area of speciality lies. I'm just going to share my screen with you, so if you just bear with me for a moment, because I need to do that, and then I'll start the slides. Oh. It's saying it's failing, which is never good. Aha, perfect. So we can begin. So I've been asked today to talk about children and their distinct legal status in the criminal justice system. So it's somewhat drier, I suppose, than what you've already heard this evening. But to begin with, if I may, I think one of the most important things, certainly from my perspective, is that language really matters, actually, and particularly when you're talking about adultification, because we hear a lot of language of youths, effectively removing those individuals that are under 18 from childhood. And so definitions matter, and it's quite important just to perhaps go back to some of the fundamental basics. And what I've tried to do over the course of these slides, because of course this is a 10-minute presentation, is just give you effectively the overarching principles, legal principles that underpin the current justice system with regard to children and young people. And so definitions really do matter. And so a child is deemed to be, in international law, a person below the age of 18 years. It's interesting as well, isn't it, that when one looks at, for example, the UN Convention on the Rights of the Child and other international instruments, a child that is engaged in some way with the youth justice system is considered to be a child in conflict with the law, which I think is a much better approach than the one that we currently adopt. And we see that even within domestic legislation, a child is the term that is adopted within some of our statutory schemes, albeit we still have a juvenile, as you can see, within the PACE codes of conduct and the Police and Criminal Evidence Act. And I think what struck me today, just before coming to deliver this part of the seminar, was that I'm currently in a trial at the Bailey, so the Central Criminal Court. And as I was leaving today, I was looking up and I remembered exactly where I was. And obviously it's a great privilege to work there. I'm not going to talk for obvious reasons about the current case that I'm in, but it did strike me that as I was leaving, that at the top of the Bailey is this beautiful statue of Lady Justice. And she carries, as you can see, a sword, the scales of justice and a blindfold. And we all see now, don't we, that blindfold is effectively seen to represent a marker of impartiality, that justice is blind. It delivers justice regardless of your wealth, your status, your class, your race, your sex, your gender, any of those aspects and more. But that's not certainly why it was included in the initial instance. And for some of us, and I suspect most people actually this evening, would probably more resonate with the original reason, which was it was satirical. And it was included effectively to demonstrate that justice was blind to the injustice that was going on and carried on before her. And it pains me greatly to say it because I'm part of the system. But that injustice continues to this day. And if you walk into the Bailey, you will no doubt see a large number of children, and obviously today's focus is predominantly on Black and minoritized boys. But you will see a large number of boys from those circumstances in that court. And without, I say, with very few exceptions, and despite the principles that ought to apply, the vast majority of them are ultimately treated as mini adults. With very few actual modifications to that approach. And so it was just one of those things that struck me as I was leaving, that it's an institution, as it's just been described, and every single part of that institution in terms of the justice system is struck through, I'm afraid, systemically with bias and with racism. And unpicking that is actually very difficult, and some of that's been identified in the questions this evening. But moving through, if I may, just very briefly, I know that we have people from all different backgrounds, so it's really a fleeting overview, in short, as to the system itself. And as I say, hopefully you'll have these slides to pick up on afterwards. But the principal aim of the youth justice system is to prevent offending. And sometimes I think we lose sight of that. The courts have a positive duty to consider the welfare of the child. But again, some might say the welfare of that child is pretty far down the list, and certainly when one's engaged, as I am currently in the sorts of work that I do. Public bodies, and that cuts across all aspects of the criminal justice system, have a positive duty again to discharge their duties and have regards the need to safeguard and promote the welfare of children. And the best interests are something that is supposed to be paramount and a primary consideration. And you see there that comes from the UNCRC, the Convention on the Rights of the Child, but it is also something that is embodied in domestic law. And that really brings me on to the issue of childhood. So children and childhood is a protected characteristic, age. And really what I think we sometimes lose sight of is treating children as children. And these aspects and bullet points come from the Youth Justice Board's most recent strategic plan. And I think they're quite instructive and helpful in that regard, and really ought to be something that flows across the system. And it's really about, as has already been pointed out, that every child's experiences are different. And really approaching it from an individual dimension. So adopting a child-first, a child-centred approach throughout the process in terms of the criminal justice system, right from the very beginning, diversion, police stations, interactions with the police, moving through to potential charge, potential diversion mechanisms there, trial, sentence, and actually the after punishment incarceration stage, working in the child's best interests, adopting a non-criminalising attitude. I'm afraid that sometimes I think we start at the opposite end of that, and working collaboratively to hopefully achieve some of these aims. And that really, I think, comes into, if you are a lawyer, how you need to approach representing some children in these circumstances. And it's your responsibility, because ultimately, we're often quite focused on the result. What will be the outcome, for example, of the trials that we're currently doing? You know, we're looking, will they get acquitted? How can we put their best case forward in front of a jury or in front of the bench or the district judge? But it's not just about the result, it's also about their treatment, their experiences, and whether or not they can effectively participate. And I've put a couple of these aspects which are contained within the guides, which I think are really actually very important in terms of how to approach this and how perhaps a child may look at it. Did they have their chance to tell their side of the story? Were they treated with respect, which is what you would expect if you were caught up in the system, and dignity? Did they understand how and why those decisions were taken in their case? Were the decision makers biased against them? And that in turn feeds into fairness and children's sense of fairness. And fairness, as we know from various research studies, is incredibly important to children who really do value and have a keen sense of what is fair and what is unfair. And perhaps more importantly, and I think there's only a very recent recognition of this, that impacts significantly not only in children's views of how legitimate the system is and how it treats them, but also on future behaviour. And when one goes back ultimately to what the key aim of the youth justice system is, which is preventing reoffending, you can see how that legitimacy is such an important pillar. And that is something that is reflected internationally. As I say, it's a little bit like the discussions and the repeat discussions that we're constantly having, and we're constantly having them about children. This is nothing new. Contained right from the beginning in the international instruments and the UN Convention on the Rights of the Child. And I've set some of that out. I'm not going to go through it in detail now because it's really, we just don't have time, but you will have it. But what I did want to do was draw that back to explain that, albeit that we have those international instruments, and historically the reaction and approach to it has been more welcoming, at present there is a very hostile reaction actually to the use of international instruments and law within the courts. And the trend towards rejecting the relevance of those instruments has continued apace, and perhaps has culminated most recently at the Supreme Court, where we have seen a sea change in the approach from the Supreme Court, either one can characterise it as a significant rowing back, or it's a situation where we've not appreciated actually how little far forward we'd actually come. From my perspective, it's a sea change. And we've seen that most recently with a rejection of what has traditionally been seen as the ways in which international law and norms, particularly in relation to children, flow through domestic law and practice, either through the Convention, the European Convention on Human Rights, and through our Human Rights Act, the domestic law, or alternatively through the unincorporated treaties. And as you can see here, there's been a very distinct rejection of the United Nations Committee that sits on the right of the child as having any authority really at all, or any binding authority, quite starkly putting it in the Supreme Court's judgment terms as it is not a court. And so that's something that's been coming for a while, and we've seen it at the Court of Appeal level in appellate work. There's been a rejection, there's been a stamping down on it, and there's been a renewed focus, and it's been happening for a while in different areas on the common law and domestic provisions. And so what I wanted to do today was just share some of those domestic provisions and resources that you really can use in your practice. I know there were questions about how do we do this? Well, there are some resources, and I appreciate that it is incredibly challenging to say to a judge or a court, effectively, you're adopting this through a racist lens. Not least because one imagines immediately it's going to cause all sorts of consternation. It can have different ramifications, but there are mechanisms, and some of those resources are actually quite useful on it, albeit, as I say, a long way to go. And so certainly take a look at the Youth Court Benchbook, take a look at the Youth Defenders in the Crown Court, which I think is particularly helpful actually on some of these issues in terms of, especially when one turns then to the sentencing and aspects, but also the compendium. And importantly, the Equal Treatment Benchbook, because, albeit I've just noticed a typo in this slide, treating people equally does not necessarily mean treating people the same. And I think that's quite an important distinction that we sometimes do lose sight of when we're looking at how to approach our cases. I'm very much aware of the time, but I'm just going to quickly zoom through a few aspects of the domestic framework. I've set out here for you the most relevant of the criminal practice directions involving vulnerable defendants, vulnerable people in court, vulnerable children, ground rules, hearings, intermediaries and the like, the advocate's gateway, the courses and the relevant sentencing guidelines. I've then sought to set out a few aspects to demonstrate how, instead of effectively reverting back to the international law norms and standards, which are nonetheless contained within some of those documents, one can really enhance or entrench rather, and ground submissions in perhaps aspects that are less challenging actually to a court and to a tribunal, in terms of the criminal procedure rules, the practice directions, and domestic case law, which is in the current climate certainly something that will be welcome far more than reference to, unfortunately, the very great resources that we otherwise have. And so I've put a little bit of that in here now for you, along with the reference to the public sector equality duty, which of course is separate to the issue of courts, but is important when it comes to when one's working with the Youth Justice Board, prisons and the like. And so I've also included those in there, and some resources at the very, very end. And really, I just wanted to end on a few words about adultification, because it's completely correct to say that children have individual experiences and every child is different. But it is all too depressing in that the same themes recur again and again and again in the types of cases that I and many of you do. And those experiences are ones that are entirely predictable, often informed, unfortunately, by systemic issues of race. And with child welfare, frankly, playing, I wouldn't even say second or third fiddle, it's far, far down the list. And intersectionality, again, and when I know that we were talking earlier about how do you address these multiple vulnerabilities. And that's the difficulty, isn't it, with adultification of children, because they are seen as effectively something that they're not, when actually they are vulnerable in so many different ways. And challenging that is actually very difficult, but it's something that certainly as lawyers, we have a responsibility to do, and we need to step up and do it, however uncomfortable. And it is uncomfortable sometimes, that makes us feel. So thank you, Ike.
Thank you, Joan. That was fascinating and really helpful for criminal practitioners, I'm sure. There are a couple of questions, but we're going to try and finish promptly at 7. So you mentioned that the Youth Justice Board is now taking a child-first approach to its work. Can you think of ways that the child-first approach can be presented in arguments to the court or at the police station?
The child-first approach, yes. So I suppose that's why I say turn to some of those resources, actually, because the principles are certainly already set out there. It's the application in practice that it often is not. And so a large amount, so look at charging standards, the gravity matrix, but also look at the policy documents. And those will set out a huge amount and wealth of material that unfortunately a lot of the time just gets ignored. And that's why I say that we have all of these principles, but how often they actually get applied is a completely different matter. And I think that it's our responsibility to really look at it and to properly use that material. And that certainly helps. And that has done certainly from my perspective in the past, but it does take up a huge amount of resources. And that's something that unfortunately when defending young people and children, we often don't have as legal aid practitioners.
Yeah, I think it's getting familiar with making these arguments all the time and then having those templates to draw on.
Exactly.
Another question, do you think we can still use the language juvenile in the 21st century? Should we be pushing to change that?
I think we should absolutely be pushing to change it. I think we should have a standardised approach, which is children. Now, I appreciate that in and of itself actually is not uncontroversial, because there are many children that don't like to be considered as children, but the difficulty is children do occupy a special status in the law, and we need to use that. And I do think that part of that language, unfortunately, then feeds into the narrative that these are not children, that 16-year-olds are not children, that 15-year-olds are not children, 17-year-olds are definitely not children. I mean, they're adults. And so I do think all of that, and frankly, juvenile has such a negative connotation in any event. You don't talk about your children as juveniles in that respect, do you?
Yeah, I think if you can get people to think about their 15-year-old, then that's always a good place to start. So if we are seeing that courts are resisting international law arguments in UNCRC, do you think we should raise them directly in arguments?
It's difficult because you want to win. often in your cases, and you want to achieve the result. And it's one of those aspects whereby it's process and result. And strangely enough, I remember when we were in the US dealing with the juvenile death penalty one, the US Supreme Court is actually even more entrenched in its opposition to the use of international law and isolationist. But you do have to keep pushing, because you do need to try to develop the law, but it's a very sensitive area, and it needs quite a lot of strategic thought, actually. And I've fallen on the wrong side of it previously and been criticised for it. And your only concern is ensuring that that criticism doesn't detract from what the court think are your good points. And so, although I would say, I think, you know, those arguments do need to be made, I think that there are mechanisms within the domestic spheres to effectively coat hooks to hang them onto. And that's probably how I'd approach it.
Yeah. Thank you. So that was the last question for you. So sadly, we've reached the end of the session. But I want to thank you and everybody else for coming. And also, please join us for the next training in the series, which will be the same time next week, 5 o'clock on Thursday, the 26th of May. The trainers will include Sandra Paul from Kingsley Napoli, talking about how to deal with racism at the police station, Bami Jolooso from the Centre for Justice, Innovation and Diversion, and Shamik Dutta from Bat Murphy Solicitors on the Gangs Matrix. Please do download and use the guides. We hope they'll help you think of ways to make stronger arguments and improve the experiences of your Black, brown and racialised clients who come into contact with the criminal justice system. And if you have any questions, please do not hesitate to contact us. Thank you.